Welcome back to InfoSec to Insanity, where we rip the bandage off cybersecurity's bullshit and fight to fix this broken ass industry. One of the things I was talking to Matt about before we started the show, I guess, or officially started the show, was I'm trying to not swear as much, which is really hard for me because I swear a lot. I swear all the time. The reason is I was kind of convicted about it. I'm a Christian guy. I love Jesus. I was reading James chapter 3 this week, which is all about the tongue. And I was like, oh my gosh, I'm that guy. You know what I mean? I got to do a better job at this because I'm not representing well. So Matt and I made a deal. Every swear word that I say, Matt gets a point. Every swear word that Matt says, I get a point. And then we're going to settle up when Matt's down here in Mexico next month. And he's going to pay me because I'm going to win. He's going to pay me $5. He's going to pay me $5.
He thinks he's going to win.
Well, because you're a Marine, man.
Oh, that is a challenge.
He's going to pay me $5 for every point that I beat him by. I don't know. We'll take that $5 and spend it on something.
Parlay it into Mexican.
Oh, man, there's a bee flying right here, dude.
It's the same one from last week.
I hate bees, man. Bees. No, I'm like a bee. I'm such a Sally with bees. With bees and with wasps. Oh my God, you see those things, man? They got those.
They're crazy long.
Their legs
surprised
hang
you
down.
didn't. You had a whole week to kill this thing, and it's still there.
No, this is a new one,
dude. It looks the same to me.
If I get stung on the show, you're going to hear some swear words. All right, so welcome back. We already said that. I'm Evan Francen, 30 plus years in this, in the trenches, I guess, of this industry. I'm still throwing punches. I don't know. I'm 54 years old now, so I'm not sure how many of my punches are landing, and I'm not sure how much they're hurting. Back when I was 30-something, man, I was kicking some ass, and I don't think ass is a swear word, so we're giving a pass on that. It's like the F word, the S word.
All the 4-letter words are not swear words.
Man, then I'm good. All right, so still throwing punches. Matt, with me is Matt Goodacre, the other guy, Logic Ninja, which makes him feel good about himself, so we build him up. That's what friends do to each other. Logic Ninja and my tether when the flamethrower gets a little too hot, which I don't like that saying. So I'm going to change that in the next episode because I don't want you touching my flamethrower, especially when it's hot. Keep your hands to yourself.
I'm thinking about carrying the backpack of the flamethrower and you're carrying the hose / sprayer because if something's going to blow up, it's the backpack. So you're protected. I would do that for you.
Thank you. All right. This is episode 45, part 4 of our series. The series name is Accountability in Cybersecurity is Broken. So part 4, if you've missed the other parts, part 1 was episode 42. And that was where Matt and I just discussed, is accountability in cybersecurity actually broken? Some people, believe it or not, that you could talk to would say, no, man, it's not broken. It's working exactly the way it's supposed to. And we used some evidence of that. We went over that poll where, I guess only 28% of the people that were polled kind of got that accountability question right. So we came to the conclusion that, yes, accountability is broken in this industry. Episode 43 then and 44 and these subsequent episodes are me suffering from ADHD, trying to figure out, what are the root causes to this? Why is it broken? And what things could we actually work on to make it better? So the next episode, which was 43, was one of the root causes is it doesn't hurt bad enough. People aren't feeling the pain. Because when people feel the pain, they demand something. They demand accountability. They demand change. And so it's curious how in our industry, we have more breaches than we've ever had. We've had more losses, dollar-wise than we've ever had. More people affected than we've ever had. And yet nobody is crying wolf. Or not even me crying wolf. Nobody's demanding change. And so we talked about that's one of the reasons. It's not, and the way you fix it is you don't start hurting people, but I don't know. We could think about that. Then episode 44, last week, it was politicians. They don't, and I shared the story of when I was younger, I actually thought politicians, their job was to represent us. It was to represent constituents. I elect you to represent me either at, in the Capitol at the state level or in the federal government. And then I found out, no, that's not their job at all. Their number one job is to get reelected. And so you think about it, like cybersecurity has never been a top 10 election issue. Number one is economy. Number two was, I don't know, I think immigration maybe or whatever. It wasn't in the top 10 and it never has been. And so we talked about, well, how could we make it? It doesn't need to be number one, but the fact that it affects everybody, everywhere in the United States, and the fact that you can't separate information security from safety anymore, like you used to be able to. It's too integrated now. There's
For
physical security
convergence
systems.
is the buzzword.
Absolutely, man. So then it should be a top 10 issue. So how do we go about making it a top 10 issue? And one of the things that we talked about among other possible solutions was, reaching out to our representatives, sending them letters and asking them questions to try to hold them accountable for representing us and maybe make this an election issue. I'll admit I didn't send any letters, but Matt, you sent 8 letters?
Yes, I sent out 8 letters to different representatives. I honestly, looking at this now, I didn't do research on like who my representatives were. I just had AI scrape some for me, and I emailed 8, and I got 3 responses.
All right. Now tell me what the responses were and who they came from.
So the first response is from State Senator Larson of Wisconsin. First question, he said, "What is your home address?" I find that interesting. Apparently, he wants to make sure I'm talking to the right person. Okay, I get it. But then he says he doesn't serve on a committee that hears any bills related to cyber, nor does he have any knowledge on these issues like he does in these other areas. However, as someone who cares about issues, he's open to working with colleagues. So he says it should likely need to be a bipartisan issue, and I should contact someone on the tech committee and study committee on AI, whatever the fuck that means. So that was the first one. I'll probably email that senator next. Then the second response says, "Thank you. Due to large volume, we prioritize constituents first. Please give me your address." Pretty sure you can find my address in all these data breaches I tagged in the email. Then the last one was actually, it looks like an automated response from the state governor, Tony Evers. He says, "Thank you. I enjoy hearing from constituents about issues that impact their lives. It's important to me. I've informed my team about your message. Please know we remember your thoughts as we work together to shape future policies." So none of them shared anything of value. Should I read the email I sent? Maybe that would help.
No, we'll
Okay.
post it later somewhere.
Okay.
5, because I do need to do this too. You know what I mean? I don't want to be the guy that's just preaching stuff and not doing stuff because, that's James chapter 4, by the way. That's what I'm supposed to do. I think what you share the letter, and then maybe I'll post it to,
Okay.
the blog and try to get other people to send letters, right? I mean, if you take this shit seriously, yeah, there's a point for you. If you take this seriously, you need to do something about it. It's not going to fix itself. The only way it would potentially fix itself is a catastrophic event, something that is going to hurt enough to where everybody's now going to do something, but we want to save people from. So anyway, this is episode 45. Thank you, Matt, for setting a good example for everybody and getting me off my butt to do it too. So this is part 4 of our series, Accountability in Cybersecurity is Broken. Last time we called out politicians, like I said, who don't give a damn because cybersecurity doesn't win elections. Can you blame them? Yeah, maybe, maybe not. I don't know. But it has to be fixed. This has to be an issue, especially in the top 10. And when we talked last week, I said, well, personally, even being a security guy, I'd put it like number 4. But it's definitely not on the list. So we called out all that stuff. Tonight, we're shining the spotlight on the legal system. Now, in full disclosure, here's a disclaimer. I'm not a lawyer. Matt's not a lawyer. I'm not qualified to give you any legal advice. Matt's not qualified to give you any legal advice. So don't take anything that I'm telling you as legal advice. What it should do, because just because you're not a lawyer doesn't mean you're not entitled to an opinion. It doesn't mean that you're not entitled for change. It doesn't mean, lots of other things. It just means that I can't represent you in court as a lawyer. They take that stuff really seriously. So tonight we're shining a spotlight on the legal system where every breach is a payday. And the data supports it. Lawsuits replace prevention, and accountability takes a back seat to billable hours. And we're going to go through that tonight. I mean, the proof is in the pudding. When you look at the number of dollars that are being spent and where it's going, this is a huge moneymaker for lawyers. So why change it? And we had a good comment, when I posted the blog post earlier today, and I need to get them off my butt and get those things posted much quicker.
It was interesting. It really was thought-provoking, especially with the previous episode we already did. So it's almost like we're on the right path.
Truly, man. And it's really cool because his comment, which we'll read online here later, his comment was, I think, justification for what we were saying last week. Right? These things are not separate from each other, but they're all things that you have to focus on if you want to fix this. If you want to fix the broken industry, you cannot do it without accountability. People aren't just you're not just going to get lucky and things are going to get secure. Attackers aren't just going to go, well, let's go do something else now. We made enough money. None of that stuff's going to happen. So we're shining that spotlight. We'll hit what the fuck news. Now that's part of the notes. Doesn't count as a swear word. We'll have to change that in the next episode. We'll also talk about CISO humor to keep us sane.
Could just say WTF.
I could. All right, we'll give you another point. So you're up $10. So CISO humor to keep us sane. And of course, the fixes, this broken system, things that, maybe you don't want to hear. This isn't a compliance seminar. I don't do those. It's InfoSec to insanity, so let's roll.
Breaches aren't just a criminal hacker's payday. They're a lawyer's jackpot. Prevention doesn't pay, but lawsuits do.
There's
Very
some truth in
interesting
that.
quote, Evan.
Well, I was just going to give you credit for saying that, man. Like you're supposed to be the logic dude. The logic ninja. So just because I wrote that down doesn't mean you have to give me credit for it. You could have been like,
I was just telling you it was good. I didn't say I gave you credit.
Well, you said it was good, Evan. Like, that's kind of like giving me credit. It's implying it at least. Next time and I can't lie. I can't tell people, nah, man, I didn't write that. That's my number one thing is to tell the truth. All right. So segment number 1, what WTF happened this week? Because I don't swear anymore. So from AT&T's $1 billion oops to law firms suing themselves, which is interesting. This week's cyber disasters prove the courtroom has become the real incident response plan. Instead of prevention, we've got a legal jackpot machine. Companies budget for lawsuits, lawyers walk away richer, and victims get monitoring they didn't ask for. So let's cover 5 news things from this past week. The first one is AT&T breach settlement. This happened last year. I'm actually surprised how fast this one went because these 2 breaches, it was more than 2 breaches. There was a lot of stuff that happened, but essentially there were 2 settlement pools that came out of this. So 2 AT&T breaches from 2024 exposed call records and social security numbers for up to 73 million people. So think about that. I mean, numbers nowadays, like we were so used to big numbers that it's like, 73 million, that doesn't seem like much. That's a lot. In the entire United States, there are 340 million people. In the entire state of California, there's 36 million people. In the entire state of Texas, there's 31 million people. So it's a lot of people when you think about it. 73 million people. And now AT&T has preliminarily, it's a tough word to say, agreed to $177 million class action settlement. The interesting thing about a lot of these breaches and the class action lawsuits that come out of them often is they're almost all settled out of court. They don't go to trial. And it's interesting to kind of point that out. The reason why they don't go to trial is because then you have to go through discovery. And when you go through discovery, opposing counsel can ask for everything related to whatever. And as long as it's approved by the judge or the court, then you have to produce that stuff. So it could easily become public, and there's a lot of dirty laundry that I think companies that are being sued in class action lawsuits don't want exposed. And it's probably, a good chance that you're going to lose it anyway, even if it did go to trial. And you might tick some people off if it does go to trial. So the damages might be more. So there's lots of reasons why they usually settle out of court. Now, affected customers could claim up to $5,000. It's like, snap, that's good money. Or up to $2,500 for the second breach for documented losses. So what you're going to have to do if you want to get this claim is you're going to have to file the claim, and you're going to have to meet whatever requirements are in that filing in terms of documentation, essentially proving, not proof beyond a reasonable doubt necessarily, but proof-ish that you actually suffered losses. Losses. Right. Most people have no clue if they've suffered any losses or not from this breach, right? I mean, was it this breach or was it that breach or was it that breach? I mean, you're going to spend so much time and money doing your own personal investigation to find out where these actual losses came from. Chances are slim, honestly. I would say maybe 10-ish% of all the people that might have been affected that are valid to file claims might file claims. So the court still has to sign off on this. This is all proposed. There's a hearing in December 2025. Meanwhile, the lawyers are already lining up their objection threats. The legal system, Jackpot, oh yeah, abso-freaking-lutely. They're asking for, I can't remember, I got to find that again, like $59 million for the lawyers. So $177 million, think of it as a big pot. There's actually two pots, but if you put them together, it'd be $177 million. 59, that's what the lawyers are asking for on the plaintiff side. So that's got to be approved. Now, at $59 million, maybe it will, maybe it won't. It's not uncommon for it to get knocked down a little bit, so maybe it'll come in at like $50 million.
Why do they even need $1 million? It's not like they're even doing anything. They're settling. They're not going to discovery. I mean, they're doing time, but what are they doing? Emailing each other back and forth? Everybody already knows due diligence doesn't have a definition, so
They do a lot. I mean, they'll spend the hours because they need to document the hours. So, and it's very highly unethical for them to, misrepresent those numbers. The false, that's fraudulent, and you'd probably get disbarred, I would assume, for stuff like that. But so all the hours that they're spending are documented for this case, what they're actually doing and whether it's actually providing value for the case. That's not for me to judge. So yes, it would be phone calls, it would be emails, it would be research that they might have done, it would have been interviews that they have conducted, depositions that they've held. I mean, there's lots of things they could be doing. But a lot of this stuff could just be busy work. Drive up as many billable hours as you possibly can. Why not?
Yeah, because there's a big pot to take money out of it.
Well, that's what you're going to be going for sure.
Yeah.
Right? And I mean, lawyers know lawyers, right? So it's not like you walk in there and, it's like the same kind of animal sort of thing. So it's pretty well understood early on that this is probably going to settle, and it's probably going to be, some ish number. So, but the fact of the matter is, and the reason why, the legal system is supposed to be about justice, right? Justice. And how is it just that AT&T pays $177 million, whether that's enough or not, it's a whole nother debate, but they pay $177 million, and a third of that, 20% to a third of that goes to lawyers, people who weren't affected by this. They're not victims of this. I get it that, they need to get paid and all this other thing, but that's why the system itself is broken. This isn't like a lawyer bashing, thing. The system, the way it's set up, is absolutely 100% broken because the victims, the real victims who should be getting larger settlements than that and not have to go through all these hoops to document. The fact of the matter is AT&T screwed up, and they should pay the price for screwing up. Whether I can document the losses of that screw up or not, that's a bar that's just too high. I mean, it's obvious you made a mistake, so let's hold you accountable for it. So anyway, when your phone bill funds legal fees instead of better security, that's the WTF angle. Why it matters: two massive breaches, $177 million in settlement cash, but the victims still need receipts to prove loss, while lawyers don't need to prove jack. That's not just.
AT&T More for your money now includes paying the lawyers who cashed in on your data.
Yeah, there you go.
So this we need to prove loss, right? That is
Well, in the settlement, it'll define what that level of proof is. It's different from in every case, I think.
just reading that probably makes 90% of people not even want to fill it out. Plus finding where these things are and go it's just over cumbersome.
Right. So I'm an AT&T customer. I would assume that I'm probably in this number somewhere. I've heard nothing. Not that I necessarily need to hear anything yet, but I'm guessing I might get an email. Maybe. I mean, I don't know. They'll also be in the whole legal settlement thing, how they need to notify and whatever. But so I get, I don't know, 300 emails a day. Will I see this one? Maybe. And then if I do see it, it'll have links on it. What's the first thing I'm going to think? This is a phishing email. I'm probably not going to click the links. Now I might, because I would do a little bit of research on the link, assuming that I saw the email. But how many people, when they see the email, they say, oh, whatever. They don't click the link because they think they're following good security protocol, which kind of is.
We trained them.
And then let's say that you went ahead and did click the link, right? So you can see the percentages continue to drop. You've got the 73 million, the numbers that actually saw your notification somehow. That number is going to be substantially lower than the 73 million. And then the number that actually click a link or reach out to find out what this is all about, that number is also going to be smaller. And then you see the requirements. Oh, I got to figure this out. I got to find this. I got to document losses. I mean, whatever the burden of proof is, whole numbers are going to, I have no idea. They're just going to drop off from that.
And the other thing is why do I even have to do this? Just give me the cash. You have my credit card, my bank account, whatever. I'm paying you. Just give me the money. Why do I have to do anything? If you're already taking responsibility,
right,
just give it to me.
Right. Now, assuming that these class action lawyers were truly representing the class, which is all the people behind it, right? They're representing that. If they're good at representing the class, you would make it as highly probable as possible that everybody that you're representing is going to get the money. So you would make sure, okay, when you send the email, you need to continue to follow through until somebody responds or follow up with phone calls, whatever is going to be the most effective way. And then the burden of proof has to be super low, because I want, instead of 10% of the class making the claim, I want 90% of the class making the claim. So I think a good lawyer and I don't know these lawyers, man. So, I mean, I'm making accusations a little bit here, but instead of me, walking away with my 50 million, or my team or the legal team walking away from 50 million, knowing that we're going to get every penny of our claim, how do I sleep well at night knowing that 90% of the people that I was representing in this case are not going to get their claim? That just seems so, again, unjust to me. So anyway, number 2, nuance. $8.5 million doesn't seem like much. I mean, crap. I crap $8.5 million every day.
Whatever.
Yeah. This is over the Move It hack. So I don't know if you remember the Move It hack. That's kind of a cloud-based file storage thing. So what happened? Nuance Communications, a Microsoft subsidiary, so owned by Microsoft. So the fact that you even got $8.5 million out of this is like a miracle. Amazing. Because Microsoft has a legal team, the size of, I mean, it's like 400, 500 full-time lawyers that work for that company. But they just agreed to pony up an $8.5 million to settle a class action after hackers abused the Move It Zero Day to steal healthcare-related data belonging to clients and over 1 million patients. Now, the thing about healthcare data, that's like a whole nother ball of wax, man, because if it's my social security number or you steal my identity, there are ways to get it back. It's a heck of a lot of work, right? You can get a new social security number. It's just a lot of work, and the federal government is super slow and all that stuff. But you can recover from that. The thing about healthcare data is, number one, I can't change it. There's no like with financial stuff, I could go to one of the 3 credit bureaus. I could see my credit score and I could see that something changed. Somebody opened an account that I didn't know about. With healthcare data, there's no central repository like that. So somebody could go get treatment with my health insurance, my healthcare data. It now goes on my medical record, and I would never know it unless somehow I had asked for my medical record. So there's been multiple cases of people going to get treatment at healthcare facilities and being treated as though they had things that they didn't have. And the one classic example, and I could go find it, but it was a lady had gone to see her doctor, and the doctor had inquired about how the baby is doing. The problem is she was never pregnant. Somebody else had delivered a baby under this lady's medical. Now that doesn't seem like, oh, okay, but what happens if if I'm allergic to something and on my medical record,
Amoxicillin or whatever.
right? And on my medical record, somebody else goes and gets treatment, and they're getting their treatment, and the doctor, says, "Oh, I see here you're allergic to blah blah blah," and he's like, "No, no, 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 I'm not allergic to any of that stuff." And so that changes. Now, when I go and get treatment, now assuming that the doctor asked me the questions, then I'll probably be okay. But what happens if I'm unconscious or whatever? I would get treated as though I was not allergic to certain things that maybe I am allergic to. I mean, there's lots of different scenarios that you could play out where healthcare data is really dangerous to be losing. So the fact that you have 1 million people that lost healthcare data, and it's only an $8.5 million lawsuit, even if the lawyers didn't take a penny from that, and every one of those $8.5 million went to the million patients, you get $8.50.
That's how much your data's worth.
So victims can choose. This is what victims can choose. And I don't know what the settlement is for the lawyers, but victims can choose 2 years of monitoring. Great. How are you going to monitor my medical record? I don't want you to monitor my credit reports. I do that already. My credit reports are on freeze.
Well, the 2 years of monitoring, what does it do? I fucking got in another breach
You just swore.
yesterday.
It's 1.
Shoot.
It's 2-1 now. Yeah.
But it doesn't stop from more breaches. It doesn't do anything. This monitoring is monitoring the dark web. It doesn't mean anything.
Right.
It's a load of BS.
Yeah. I mean, if you could monitor my health record, I go and get treatment and you're like, yeah, you're dead. I don't know.
It's like pulling the wool over the normal people, not techie people's
People don't pay
eyes.
attention. People don't have any idea about most of the stuff that we're talking about. Even people in our industry don't know about these things, which we should, because it's not just. And when you see something that's not just, and I'm not blaming the lawyers. I'm not saying the lawyers aren't just. I'm saying the system is not just. So if you're okay with people continuing to get screwed over, well, then let's just keep on going with the status quo. But the problem is I'm not, and I don't think anybody should. We're supposed to, this is a service industry. Cybersecurity is a service industry. Our job is to serve people. We're supposed to be doing a heck of a lot better job than this. So anyway, you can choose between 2 years of monitoring, small cash payouts for losses, or a flat $100.
Ooh.
Thank you. The WTF angle, when a 0-day zeroes out your customer trust, but the biggest winners are attorneys. Why it matters, victims get $100 or monitoring. Law firms walk away with millions. Prevention costs less, but settlement costs get baked into budgets. People actually budget for these things.
Nuance, more like no chance against lawyers smelling breach money.
Bingo. Number 3, WorkWave. If settles $1.5 million settlement. Now, these might seem kind of inconsequential, like $1.5 million. That doesn't seem like that much. We'll talk about bigger ones here in a little bit. But $1.5 million for most companies is huge. Most companies are small businesses, and a $1.5 million settlement would put most of them out of business. But I'm not saying that's what happened with WorkWave, but you have to, even a $1.5 million settlement, we shouldn't just like, a big deal. Who gives a crap? Somebody cares. So they agreed to a $1.5 million settlement over a July 2024 breach, exposing names, social security numbers, and driver's licenses. Affected individuals can claim up to $5,000 to cover documented costs like fraud like fraud recovery or identity restoration. So again, it's not
identity restoration.
Oh, it means somebody stole my identity. So I'd have to go through all the work. Well, I'd have to get a new social security number.
On all the, gotcha.
I'd have to go to all the accounts that were opened under my false identity. And yeah, it's a lot of work.
Close them. Yeah.
So in this case, then you're not getting anything. So your name, social security number, driver's license was all exposed, but you're not entitled to anything according to this unless you suffered something. Now, the thing is they put this money into a pool and it sits there. It sits there for some period of time, right? And it's all in the legal agreement-y things. I don't, it's different for each one. And every legal agreement, for these settlements is like, from the ones I've seen anyway, they're just different. So the money that's not claimed, some people think it goes back to the company, right? So, in the Equifax breach, anybody who didn't claim that money goes back to Equifax. That's not what happens. I don't know if that ever really happens. There's some legal terms on things that they do, but I think what typically they do is they give it to some nonprofit or something, or some cause or something. I mean, whatever it is, the judge has to approve it, or the court. So anyway, if you don't suffer anything from this one, which you did suffer because your data's out there, whether they're using it or not, or maybe they're using it and you don't see it, right? But they're not using it to steal your identity. They're using it to do something else, right? And let's say they, because I think a lot of what's happening with identity information, privacy information, is it's sitting for a while, and then it will be used when it's going to be used. But I know for sure that my identity has been stolen, not stolen, but my identity information has been exposed many times. And I've yet to have my identity stolen. And so I would assume it's only a matter of time. That's why I live in Mexico, because I already escaped the United States. I can get myself a new identity down here in Mexico. All right, so the WTF angle: when your company name sounds like a productivity app, work Wave, but waves goodbye to security. Why it matters: another class action jackpot. Breach, settle, repeat. The company pays $1.5 million. Lawyers profit, and security is still an afterthought.
Wave, moving fast, breaking things, making attorneys rich.
Show me the money, dog. Show me the money.
So you talked
Dang.
about productivity app. I mean, Workday was just in the news this week from their incident too.
WorkWave?
Workday.
Yeah.
Where's
There's another one
for part of Snowflake rollout still. That Snowflake thing that no one wants to acknowledge affected pretty much everything.
Ever.
Yeah.
Here's one: Hallberg and Associates. Hallberg has associates, and he or she and the associates they had a breach, and it hits employee data. So a recent breach at Hallberg and Associates compromised sensitive employee and contractor data, including social security numbers and bank account information. The firm offered 24 months of credit monitoring to victims, but this one's already looking like a candidate for the next class action lawsuit. WTF angle: when your financial consulting firm, that's who Hallberg and Associates is, they're a financial consulting firm, but when they prove that they can't even manage their own data, I don't know if I want you managing my money. I want somebody who actually takes it seriously. I don't know the details of this breach, and we know, right? The truth, the way this game that we're playing is called risk management. It's not risk elimination. So no matter what you do, no matter what Hallberg and Associates did or could do, they could not have prevented all breaches from happening. So we're not looking for risk elimination. We're looking for risk management. So the questions then for Hallberg and Associates are: do you have an asset inventory? Do you have an inventory of the hardware, the software, and the data that you maintain within that organization? That's a legitimate question. And if the name of the game is risk management, show me your last risk assessment. Show me what you've done with your last risk assessment. And the fact of the matter is, assuming you wouldn't be happy with the answers that you'd get. So why it matters: social security numbers and bank account information, info in the wind, employees left exposed. With lawsuits looming, the firm's future looks more like Hull broke. I made a joke.
They
Instead of
manage
Hallberg, it's Hull
money all
broke.
right.
Yeah. Go ahead, man.
They manage money all right, just not yours after identity theft.
There you go. The last one: U.S. law firm hits the jackpot of its own data breach. So, boom,
Jackpot.
in your face. So what happened in a delicious twist of irony? I like that I put the word delicious in my notes because I never tasted
Delicious.
a breach before, but I can assume if I were to taste one, this one would be delicious. So the delicious twist of irony, Kelly Dry and Warren, an actual law firm, is now on the receiving end of a class action lawsuit thanks to a cyber attack that compromised names, social security numbers, birth dates, and driver's license details. The plaintiff, a former employee of the client, even claims the breach notice downplayed the risk. No, that never happens. Why would they downplay the risk?
It's almost like we got really good at PR.
Yeah, okay. So I'm guessing that's not going to be hard to prove that one. But it prompting increased scam attempts. Now the firm is staring down a legal suit and its own profits from justice. The WTF angle when lawyers cashing in on breaches become defendants themselves. Why it matters, a law firm that made millions suing others for negligence is now eating its own dog food. Maybe the courtroom jackpot isn't so fun when you're the prize.
Kelly Dry got hacked, and now they're Kelly Cry.
Yeah, I did write that one. I have to take credit for that one because that one was, I laughed when I wrote that one. Thank you.
Rhyme.
All right, so this week's headlines show the new breach economy, and these are only 5 that I found actually this afternoon because I didn't prepare well for the episode. So the new breach economy: hack, sue, settle, repeat. Let me repeat that: hack, sue, settle, repeat. Hack, sue, settle, repeat. Hack, sue, settle, repeat.
It's
You can make a
almost
song out of
like
this.
it's almost you could mix that with the attack, right? You know, gain access or exploit, gain access, elevate, pivot, persistence, right? Make all of that into a thing because it's all the same. That's never fucking changing. Damn it.
You just swore again. We are even. I don't owe you any money. You don't owe me any money. Right now it's back to 0-0. We're tied. 2-2 if you wanted to keep score. All right, so this week's headlines show the breach economy. Like I said, hack, sue, settle, repeat. It's a system where failure pays, and the biggest winners aren't the defenders. It's not me and you. It's not the victims either. Who's the biggest winners? The lawyers filing the paperwork. CISOs and customers keep losing while the legal industry keeps winning. Speaking of losers who need therapy, let's roll into segment 2, CISO humor. And let me just say this one more time. I'm not ripping on lawyers. Not that I'm afraid of lawyers. I actually don't respect most lawyers. I think most lawyers I don't like lawyers, So the reason why I'm not disrespecting lawyers is because they're not the problem. They're part of the problem. The problem is the system. If you put most people in front of file this paperwork and work on this case for 12, 13, 14 months, and you have to do all the lawyerly, whatever stuff, and you're going to make the firm $54 million. Most people would take that. So I don't blame that. I think in a lot of cases it's unethical because the money you're taking, you need to ask. There's nothing wrong with having boatloads of money. I like my money. But I sleep well at night, every single night, knowing I didn't take advantage of anybody to get it. I didn't steal it from anybody. I didn't sell them something that didn't work. There are times when I made tough choices, but I didn't take advantage of anybody to get my money, which is awesome because there's no amount of money you could possibly give me that would give me the peace that I need to sleep well at night. And that's the kind of attitude I think most of us need to have in this industry if we want to fix it. So anyway, I preached a little bit there. Hallelujah. All right. So the CISO humor, this segment, its title is Exhibit A. Your security is a joke. Exhibit A, like you're presenting this as evidence. So the opening riff here, welcome to CISO Comedy Hour, where your evidence is a pile of ignored risk reports. Your witness is an intern, and the only ones getting justice are the lawyers billing $800 an hour.
Might be a CISO if your breach response plan starts with, please rise, court is now in session.
That's your breach response plan. Yeah. You might be a CISO if you learned more about cybersecurity from your company's lawyers than your security budget.
Might be a CISO if your boss said, don't worry about the breach. We got a great attorneys.
I've heard almost that same thing before.
Pretty close.
You might be CISO if your risk register is now Exhibit A. Make sure that risk register is pretty tight if it is going to be Exhibit A. All right, we got a courtroom skit, Matt. Now, this is new here. I don't know how this is going to, we're going to have to kind of act a little bit because
Yeah.
like we're going to have to switch roles because I think this is more of an act for like 3 people, maybe 4 people to play.
That's
So we're going to
fine.
switch a little bit. You have to switch voices a little bit like, hi, I'm Matt. You know what I mean? So the opening scene, imagine this, because we need to get sound effects on this podcast too, by the way. There you go. Sound of a gavel slamming, echo of a crowded courtroom. The bailiff shouts.
All rise! Cybersecurity Court of Injustice is now in session. The Honorable Judge Goodacre presiding. Be seated. Today's case, the people versus accused of gross negligence for failing to prevent a breach. Prosecutor, your opening.
Your Honor, the defendant failed to implement reasonable security measures. Millions of records leaked. And my clients, well, they deserve justice in the form of $700 million, of which we humbly request 1/3 for our tireless efforts.
Proceed.
Your Honor, I submitted a risk report. It was ignored.
Irrelevant. Did you stop the hackers?
Well, no, I asked for a budget. I asked for a budget to stop them.
Objection sustained. Budgets don't matter here. Did you or did you not configure MFA for all users?
We had a roadmap. I mean, I was doing the best I could. We had a roadmap, but leadership delayed it.
So guilty. Ladies and gentlemen of the jury, I rest my case. Now about 33% my cut.
Can I countersue? Can I countersue leadership for negligence?
Out of order. Only lawyers get to profit from negligence in this courtroom. Case closed. Sentenced to 2 years of credit monitoring for the victims and a new Tesla for the law firm.
All right, gavel slams, crowd groans, laughter track. There you go. That was kind of fun, man.
Yeah.
I think you play a good judge. You started out like very like, all rise. I mean, you scared me a little bit.
I got distracted by having to do 2 in a row. I was like waiting.
Yeah.
But it was fun.
All right. Yeah. We'll try to do more of those. And we're only going to get better at this, I think.
Yeah.
All right. So real talk, CISOs are stuck cleaning up messes while lawyers decide what, this is one of my biggest frustrations, quote unquote, reasonable security means without knowing the first damn thing about multi-factor authentication, asset inventories, or patch cycles. And I'm not saying this about all lawyers. There are some lawyers who I think are pretty good with knowledge on security, but they're not security practitioners. There's a difference because the thing you miss with knowledge, book knowledge versus practical knowledge, is the wisdom piece. The book says it's supposed to work this way. Well, what happens if it doesn't work that way? That's where the experience comes in. And again, the name of the game is risk management. So there's many ways for me to mitigate unacceptable risks, but I've seen enough, and I'll share some of my own experiences when we get into the main meat of this episode, where lawyers are smart, but they're not looking for what's a good security program. They're looking for, are you doing what reasonable people would do? Meaning, is this what everybody else is doing? So essentially what that means is if the entire herd is running off a cliff, that's okay. Because as long as you're in the herd, it's hard to find you negligent. That's a big problem because the herd is running off the cliff. So
I know this company is a Wisconsin company and they're probably, competitors to your businesses. They talk about duty of care, and there is something with, because they're kind of like a lawyer company.
due care and due diligence.
Yes. But I guess there is, whenever I hear them talk, I guess there is, I can't remember the term, there's like a Sedona conference. That's it. There's like a lawyer conference where all the lawyers get together and stuff. And it seems like this group is trying to push that CIS is the measurement of due diligence
CIS
because,
has no measurement in it.
well, it doesn't have like a measurement itself, but that's like what I'm trying to get at is the first part is asset inventory, which is exactly what you're always talking about. So like
Well,
it
and
should just be that simple.
if you truly wanted to, we'll get to this. Let's finish up this segment and
Okay.
let's get to that because I think we want to talk about what doesn't work. If you wanted to fix this, I think what doesn't work is to give people a whole bunch of things and say, if you're not doing this whole bunch of things, then you're negligent. I think you have to meet people where they're at. People are typically able, and you learn this stuff just from social engineering over the years. Like most people can handle two things. Everybody can handle one thing. As long as I'm giving you the one thing that you're actually capable of doing, everybody can do that. Two things. Push it a little bit. But so what are the two things? What I can't give them 20 because even in the CIS controls, it's more than 20, right? I mean, you got a whole bunch of sub stuff.
7, but they're sub down into like 12.
So yeah, we'll get into that. That's a great, I like that point you brought up. All right, so next time, here's a CISO survival tip. Next time leadership says, we'll let the lawyers handle it, ask, do they also handle patching servers?
I don't need therapy. I need a legal team that knows what MFA is. I mean, here's the thing about MFA and organizations. What year is it? 2025. I am flabbergasted that anybody
That's a big word.
working
Are you a
for a
lawyer?
business is arguing that MFA is hard or burdensome. You use it for your financial stuff. I mean, ideally for your email, like you're getting everything has it now. Well, not everything, but like it's everywhere. So like that's just bullshit.
I'm up $5 right now.
That's a one word that whatever.
No, you can argue all you want, man. All right, enough of the laughs for comedy court. Because in the real world, these courtrooms aren't skits. They're business models. Every breach turns into a jackpot for lawyers, while CISOs, like us, get dragged into the witness stand and customers get the scraps, if anything. Most customers don't get anything. The latest numbers I saw, it was 13% of data breach victims actually file the claims to get, part of the settlement. So 87% aren't getting anything. So 13% get those scraps. Let's leave the jokes behind, well, some of them, and we'll dig into the ugly truth, how the legal system is cashing in on cybersecurity failures and why prevention will never win as long as lawsuits pay better. So that's segment 3. So the blog post.
Meat and potatoes.
The meat and potatoes. The title of the blog post is Breach, ? Jackpot. How the legal system profits from failure. And so this part of the podcast is you and I discussing our thoughts on these things. Every day, every breach is a payday. I mean, not just for criminal hackers. The criminal hackers don't give two craps. They're off with their data and doing their things. But the law firms also, are getting the big payday. 2024, last year, nearly 1,500 breach-related class action lawsuits were filed. That's triple the number from just 2 years prior. So in 2022, it was around less than 500. So it's gotten worse. This is big, big money we're talking about. I mean, we talk about 1,500 breach-related class actions. I don't know what the numbers are. I'd have to do more research to find out how many of those actually settled and for what dollar amount. But lawyers are making tons of money on this.
If you're a partner.
Even if you're not a partner, man. I mean, win a couple of these cases for your law firm. It won't be long before they'll make you a partner. I mean, there's good money. So there was a comment on this blog post that I'm going to read because I thought it was really interesting. And it was shortly after I published the blog post. And I'm going to read it off. It says, "Thank you, Evan. You're right. The incentive system is badly broken, but it's not the fault of the lawyers. The lawyers actually can't change the system. It's the fault of the legislators and regulators," which we talked about last week. So this drives home what we were talking about on these are all interrelated with each other. It's not, you can't point your finger at just the legal system. They're all interrelated. So the incentive systems now in place encourage negligence and criminal recklessness. They encourage short-term thinking, which is actually coming up in the fifth part of this. They encourage short-term thinking instead of long-term needs. This must change, but unfortunately our system doesn't change until things get really bad. That's back to episode 42, 43. So the proverbial Pearl Harbor moment. I would have thought that we would have passed that point already, but evidently we have not. The lawyers are simply trying to get compensation for the wronged parties, settle disputes, etc. The damages paid, the bad press, the high fees of the involved lawyers, etc., should be considered a strong deterrent of bad behavior on the part of boards and executive management. Thank you for addressing this serious problem, which is unfortunately all too often swept under the rug. I write this as an attorney and also a longtime specialist in information security and privacy. Such animals exist. I loved it. I thought, that's a fantastic perspective. And one of the things you and I were talking about earlier today, Matt, was how we talk about things I think that other people don't want to talk about.
Yes,
People don't
sir.
want to talk about this stuff. And I don't know why you wouldn't want to talk about it.
I feel you don't want to talk about it because you're not driven by service, you're driven by money. If you're driven by money, it's all good.
Yeah, I guess.
I think
That's maybe part of it.
we breed a culture that is driven by money.
Yeah. More so than I think in the past, probably. Yeah.
Mm-hmm.
Well, I think there's also a group of people that don't know this. They don't know that nobody's talking about it. So I never heard of it. And it's an uphill climb too. I mean, when you stick your neck out and talk about things that nobody else wants to talk about, the reason they want to talk about it is they don't want to be the target, right? I mean, if you say something that I make enemies, either with, this group or that group or attorneys or whatever, who wants that? The good thing is I'm at this point in my career where I don't care. The days I have on this planet are numbered. I'm 54 years old. I'm not going to live to 300 years old, right? So there's some number where this is going to end, and I better make it count. I don't want somebody to say, well, why didn't you ever say it? Why didn't you ever do something? Well, because I was scared. No, I get paid. I get paid to tell people the truth. I don't get paid to tell people what they want to hear. If what I'm telling you is what you don't want to hear, well, then I'm sorry. I'm sorry for you. I'm sorry for what I said. And you're not screwed, Matt, because I think people are going to value this.
Thing.
People are going to value this. There's three things you need if you want to make a new customer in this industry or a new, friend. I mean, I used to say this with FR Secure. If you want a new customer, you have to have trust, credibility, and likability. So the fact that I say things that are true and I'm open to challenge, I mean, I'm doing the podcast, putting it out there. So if you want to challenge me, come on, let's go. Tell me your perspective. I'll respectfully listen to it and I'll respectfully disagree or agree. And I would expect the same thing from you. But if we don't have these conversations, then I'm not going to sleep well at night because I know I didn't say something I was supposed to flipping say. And that's what people need to get in their heads. Like if you see something wrong, you need to do something about it. That's the way this game works. And if you're interested in money, the truth is, if you focus on the mission, meaning doing this the right way, you will make money. I have plenty of money. If you focus on the money, you don't make the mission. So that's how it works.
About Kennedy on TV today, presidents and accountability.
JFK,
and Kennedy,
John?
John F. Kennedy, he did the Bay of Pigs thing. That was a big disaster, but he owned up to it and took accountability publicly. Like, you could see that weight on him. I'm wondering, when did that go away? No one in those offices take accountability anymore, and it feeds into corporate and everything we're talking about right now.
Well, I think that's part of it too. But even back,
by the way, geckos are carnivorous small lizards.
All right, so I stand corrected, Riker. I'm sorry about that. Well, I think because I get this excuse a lot. Well, this industry is still young. It's young, relatively young. Okay.
Yes, in the grand scheme.
Which I sort of okay, but don't use that as an excuse.
As a teenager, should you be getting more mature?
When you see something that's broken, you fix it. You don't say, well, It's just because we're young. No, fix it. Fix it. Otherwise, it's not going to get better. It will get worse if you don't fix it. Right. So being in this industry since, the early 90s, late 80s now, I guess. I mean, I'll think through all the crap. It's always been broken. And it wasn't broken so much because of greed earlier on in the process. It was broken because of confusion. Everybody was like, man, I don't even know what this is. And I think, we'll talk about that next week when we talk about vendors and we talk about how we perpetuate the problem ourselves. So if you want to point fingers, you can look in the mirror because we oversell fear. We keep things complicated. People are confused. There's this. Anyway, that's next week. So anyway, the legal gold rush, Equifax. I brought that one up earlier. $700 million settlement. How much do you think went to the attorneys?
Not as much as you would think for this size based on the last one we talked, but yeah, what, 78 million?
Say $77.5 million for attorneys. Victims, you get $125 and a free credit monitoring coupon. And here's the thing about your free credit monitoring coupon. Your provider of this free credit monitoring is Equifax, who does credit monitoring. So it's like, that's no skin off their back whatsoever. But what they did in that settlement is they put a dollar amount to how much they could charge for this credit monitoring that they already do. And if we offer it to, I can't remember how many people were involved in that breach,
I think it was like
170 million
it was
people?
like half the country. Yeah.
So 170 million people, and let's say that we normally charge $20 for this service. Legitimately, maybe part of that 700 million. I haven't looked at the settlement, so I'm just
All I know is
hypothesizing.
if you log into Equifax now to like freeze your credit, there's like, oh, click here to subscribe to the dark web, and you can do the super ultra freeze credit.
Yeah.
The fuck does that mean?
Don't get me
Just
started
freeze
on
my
credit bureaus,
stuff.
man. Actually, we'll have to do another series on credit bureaus, how much of a scam that is.
Yeah, right.
It's crazy. Anyway,
I
AT&T.
swore again, by the way.
Oh, did you? So now you owe me $5? No, you're down 2.
10.
Nice, man. I got to pay for this. What? Oh, I'm going to buy a Harley in October. Buy another Harley. You won't be here in time. I mean, I won't get it in time for you to see it, but I'll send you pictures and you can come down.
Just
later.
had to come back. I still have to come
Yeah.
down in the actual good time to watch the whales.
Because Harley's really close to where you live, right?
Yeah, it's like right there, like 10 minutes. Yeah, headquarters.
Getting a
One of those electric ones?
No, that is the stupidest thing. I would never ride an electric Harley. No, it's the Pan America. Have you seen those?
Looking right now.
Pan America Special. Oh man, it's a beautiful bike. I've seen it and I've been watching it for a while. And I had to get my wife to a point where she's going to let me do it. Then she said I could do it now.
Ooh,
sweet.
So it doesn't look like a Harley. It looks more like a rocket.
No, yeah, it's their first entry into kind of the crossover bike. So it almost looks like, a lot of the BMW bikes.
Yes, yeah.
But this bike is badass, man.
It's a Harley.
150 horsepower. It's got sweet components on it, man. It's, yeah.
Not that expensive.
I want to ride that really badly. So maybe if I can get one of these settlements, if I can figure out how I'm going to pay for it. All right, so AT&T 2024, like I said already, $177 million settlement. What's been requested? I couldn't remember when I said it earlier, requested for attorney fees. This will be finalized allegedly by December. Rector, that's a good bike. Glad you're staying American. $59 million is what the lawyers are requesting for their cut in that breach. Now, here's the thing. Breaches happened last year. So it has hardly even been a full, I don't think it even has been a full year. And so these lawyers did $59 million worth of work in like a year. How many lawyers you got on this thing, man? And what are they charging? I have to go look deeper into this one because holy moly, $59 million in a year. Yeah, whoever's leading that one's definitely becoming partner. T-Mobile 2021, $350 million settlement, including millions for future improvements, quote unquote, future improvements. that should have been done before.
They got hit again, what, this year or last year?
Of course, their future improvements may not have been so improvementy. Well, a lot of times, have you read? Well, maybe not. Maybe I'll have to
What
publish
do
some
they
of that
do for
stuff.
improvements? Buy more Microsoft licenses.
It's usually stupid stuff. It's usually stuff that doesn't fix the root of the problem. You know what I mean? It's
I need more Dark Trace. I need more CrowdStrike.
Capital One breach 2019 settled in. The breach was in 2019, settled for in 2021. Total customer restitution fund of $190 million. Lawyers received $53.2 million in fees.
That's a lot. Who's in your wallet?
Yep. Victims received the remaining fund, $136.8 million for cash payments up to $25,000 for out-of-pocket losses. Again, you'll have to demonstrate those losses. It's not just, oh, I lost a bunch of things. You're going to have to prove it. And up to $25 an hour for up to 20 hours of time spent, plus non-cash benefits like up to 5 years of free identity defense monitoring and restoration services for 100 million people affected. AT&T, we mentioned already. Yahoo, you remember that one? That was a huge
everything.
Breach. 2013 to 2016. That's how long that breach went on. And there were multiple attempts to cover that up, right? I mean, it was, if there was a case to make for criminal charges, that would have been one for sure. So the breaches from 2013 to 2016 settled in 2019, total customer restitution fund of $117.5 million. What kind of lawyer could only get $117.5 million from Yahoo on that breach?
Yeah, they should have gotten everything.
I mean, I'm not a lawyer, but give me some certificate or some bar thing. Just say I passed it and I could get you more than that. Lawyers received $23 million in fees, reduced from a $30 million request. So they requested $30 million, got 23.
I just found this one. It looks like as of today, they're settling the Marriott breach. That one was a decade long, if you remember. That
was a long time ago. Yeah.
That was from a merger they had.
Yeah, Marriott actually bought that breach.
52 million is what that one's going for 10 years of compromise. And
Such
it's
a
going
moneymaker.
Distributed to different states. And customers, what does it say here? 5.2 million guests. It doesn't even say what they're entitled to, but it's just disgusting.
Here's Meta 2024, $0.4 billion biometric settlement because your face apparently makes a great payday. I don't know what the lawyers got in that one, but if you do go with a typical 10 to 20%, lawyers made bank on that one.
So I don't know a lot about the other companies, but 1.4 billion for Meta is like a slap in the face.
Yeah. Yeah, when you put it in the like context,
yeah,
it'd be like giving me $1,000 fine. Yeah, I mean it's an inconvenience, sure, but it ain't changing anything. I'm still going to buy my Harley. My wife is still going to be with me. I'm still going to make the house payment. It's like, okay. The WTF angle, class actions are booming because prevention doesn't make anyone rich. Lawsuits make people rich. To your point, Matt. Why lawsuits fail prevention? Lawyers aren't cybersecurity experts. Not some are. Some are. Most far from it. They argue negligence without knowing what MFA even is, or the importance of asset inventories, or the importance of risk management, risk assessments, roadmaps. Courts are crazy inconsistent. One case says bad configs of software is negligence. Another says no substantial harm. And I covered that a little bit more in the breach or in the blog post. The truth is, without any clear standards, lawsuits chase payouts instead of change. People budget for this. Companies treat lawsuits like business expense. There's your cat again.
She looked sad on the floor, so I picked her up.
So practitioners, we know the basics, do we not? Asset inventory, multi-factor authentication, because part of your asset inventory is also configuration management, I would assume, right? So I know I have these things. What's the proper way to use these things? Because somebody made the choice to put those things in the environment. And if you chose to put those things in the environment and not put them in the environment the right way, how can you not be to blame for that?
It's hard, Evan. It's hard. I gotta work with other people. It's hard,
Then slow down. Stop buying so much damn technology.
but I gotta make money. The business is pushing.
There's lots of ways you can make money. You can make more money cutting your asset inventory, getting rid of assets that you don't need, streamlining your processes, which all reduces complexity, which is all the best friend of information security. Go that way. Stop being stupid. But we have no universal standard. Companies can skip them without legal consequences. FTC's reasonable security, the standard is too vague. What we need is black and white. If you don't have an asset inventory that meets these requirements, you are negligent. Period. Start with that first one. If you want a second one, then I like the multi-factor authentication one, because that is the number one way into most environments, is a single factor authentication, something that's exposed.
Is it storming by you?
Yeah, man.
Nice.
Hurricane
Season?
Hurricane, whatever you want to call it. So California CCPA, I'm not a fan of CCPA, but it is the closest, but it only applies to Californians. Result, endless lawsuits, no systematic change. The accountability gap, here's how it works again. Company gets breached, lawyers file suit with vague negligence claims. Settlements reached, law firms pocket millions. Company patches, bare minimum, next breach, repeat. The company probably budgeted for it, the breach. And so how do you make prevention? Because this is a knock on us as security people. There are so many, dare I say, poor practitioners in this industry, for whatever reason, that don't know how to justify their budgets. They don't know how to justify an information security budget. And if you need to base it on risk, right? The name of the game is risk management. So where's my risk? If I do these things, where would my risk be after that? So you do have to have some form of measurement. The measurement has to be objective. Measurement has to be consistent. Otherwise, it's not a valid measurement. So, I mean, these things are basic stuff, but not enough cybersecurity professionals are taught the basic stuff like this. If you're going to manage information security, this is how you do it.
Taught how to hack and crack and capture flags and things like that.
Because I could 100% give me, I don't know, any one of these companies here, AT&T. Oh God, I'd hate to work for AT&T.
They got a lot of assets, I bet.
But you give me a half of the $177 million in a budget, I will make this not happen again. This one. And chances are there's probably enough crap in that environment, hardware they don't need, software they don't need, ghost IT everywhere that they can't seem to get their hands around. There's probably enough to save in reducing the complexity of the environment to pay for that. So I don't know. But the thing is, nobody holds AT&T accountable. How many customers left AT&T because of that breach?
Nobody. Their stock's actually, like, I'm mad because I sold my stuff early, but it's up very high right now.
I mean,
Almost
AT&T,
$30.
the hassle for me to go change from AT&T to T-Mobile or something else, it's not worth it. So then they know
At least
that.
you can keep
The
your
lawyers
phone
are
number
smart
now.
people. Yeah, it's crazy. All right. So all that stuff, accountability gap, we talked about that. The reality check, the system doesn't hold accountability. The current system doesn't hold companies accountable for prevention.
Do you
It
think
rewards failure with predictable payouts. That's different.
Do you think it doesn't hold accountability for prevention because there's so many people that say it's not if, it's when, you can't stop it, it's going to happen? They have that mindset versus the risk management mindset.
Well, there's always excuses. But one thing that would go a long way, and we'll talk about this when we wrap this up, because we don't do this podcast just to sit here and complain about everything, right? Lazy people do that. Lazy people just complain, point fingers and sucks. Everything sucks. We're not lazy people. So we're going to give you some fixes, at least ideas for fixes to start the dialogue, right? This is how I would fix this if I were to fix this. Stats just before we move on to that next piece: 2,000 2,000 plus breach class actions clogged U.S. courts in 2023. So I mentioned before that we had 1,500 last year. This is the backlog in 2023, more than 2,000 breach class action. Dang, that's a big business when you put all the dollars to it. Victims often get less than $200 for credit monitoring. Attorneys in Equifax, Capital One, AT&T scored $50+ million fees in each. Only 30% of boards align cybersecurity risk with business goals. They don't see this as being a problem. Until they see it as being a problem, why would you expect it to change? All right, key quote: prevention doesn't pay, but lawsuits do, and the courtroom has become the new incident response plan. Let's get into our broken industry fix list. So we just did a whole bunch of complaining, pointed out how bad the problem is and whatever, and gave our opinions. Now let's go through a list of 5 fixes. We have 5 fixes for you, starting with what Matt's got. What's number 1?
First, I want to ask you a question from the chat.
There's a chat
How
question.
much budgeting is needed if there is insurance policies that companies can buy should they have a breach?
It's a whole nother ball wax. Maybe I'll
I'm
make
not,
that the next episode. Or not the
I
next
don't
episode,
know
but
the answer to
trailing.
that. I would just think you go through it, whatever they charge you is your budget. And then afterwards, you ask them for the 5 things, because usually there's 5 things that they focus on. Fix those 5 things, and then it'll probably be less the next time. That's just what I
Well,
would
insurance
think.
policies are all going to cover what they're going to cover. An insurance company is in business to make money. They don't make money when they pay claims. So they're going to look for every possible reason to not pay you a claim. So you're going to have to go through your application. If you lied on anything on that application, and a lot of the questions that they ask in those applications are pretty much are open to interpretation. A lot of them are not binary questions. They're not objective questions. And they ask those questions on purpose because there's a little wiggle room for maybe they don't have to pay that claim. So the insurance company doesn't work for you. So, take that into account. And insurance is only to cover loss. So you'd have to calculate what your losses would be. And in order for you to actually do that, this is the thing when people get screwed up on justifying their budgets with dollars and cents. You can't do that because you don't know the value of the data. That's a key component if you want the math to work. And I've had this beef with CPA firms and others. Like, everybody says that data is an asset, then why don't I see it on a balance sheet? Why isn't it listed as an asset on the balance sheet? Because then nobody took the time to value it. Nobody took the time to put a dollar amount to it. So it's all just kind of arbitrary. We're just like, oh, it's worth a lot. That's part of the problem.
Thank you for the tangent there.
Yeah.
Hope that answers your question.
Give us 5 fixes, man. Start with number 1, fixing this thing we talked about.
Define negligence clearly. Set universal, enforceable standards. Asset management, MFA, patch cycles, and tests. I would probably even argue take out pen test and do tabletop.
Whatever. I mean,
if you skip the basics, it's negligence. Period.
Make it that cut and dry. Whatever you decide to put on that list is an improvement over what's currently on that list because that list doesn't exist. That's the problem. So if you said asset inventory and MFA, or you said asset inventory and an incident response plan that's been tested, or you say asset inventory and a risk assessment following these practices, whatever you decide to put on that, I would advise not going more than 2 to begin with. Give people an opportunity to live up to your 2 and then keep adding on to it. It's like,
I'd say 5.
It's like trying to take a baby and like, hey, let's go run the marathon. I mean, that's where the maturity of most information security programs, it's like, you ain't ready for this. That's the big beef I have about people buying a lot of the products they buy in our industry. Like, you're not ready for that. You don't even know how the hell that thing works. And you just justify a budget to dump that into your system and misconfigure it.
It just works out of the box, Evan.
Plug and play. I've been promised that since they first came out with plug and play, and it's still never been plug and play. Fix number 2, educate the legal system. Lawyers, judges, They need to have some bar of cyber literacy. They don't have to be necessarily experts, but they have to understand like the importance of these things. And just because a company, all the companies don't have this thing, that doesn't make it okay. There still needs to be some, repercussions for that. So partner with NIST, CISA, some industry body, whatever, to figure
Partner
out
with
like
us, we'll tell you.
lawyers, but I wouldn't be able to do that with the lawyers probably. Because, all right, reasonable
That's why I'm
security,
here.
quote unquote, reasonable security. That's a subjective term. I look at it, I'm like, that's clearly not reasonable. You look at it like, seems reasonable to me. Everybody else is doing it. It goes back to that herd mentality where people are running out. The whole herd is going towards the cliff. And you're watching it and you're like, all right. I mean, I'm trying to pick off people in the herd and like, no. Let's move the herd this other way. So reasonable security should mean something more than whatever the lawyers argue. It needs to be educated. That's number 3, man.
Shift incentives to prevention. Offer tax credits or insurance discounts for companies meeting recognized security frameworks. Make proactive security cheaper than paying off lawsuits. That this is something I've thought about, and I asked this, man, a couple of years ago. Like, oh, you could use, security frameworks or like high trust or whatever these things are, right? For marketing to generate revenue. And they're like, oh, we don't want to introduce security into sales. Bullshit. I think that should be part of it.
Another one for you, by the way. You just use the same word again. That's like 3. I'm kicking your butt right now. Butt is not a swear word. I have one. I'm sitting on it.
The gluteus maximus.
All right. Another thing about there's actually a case study, a really big one, by the way, that a lot of people don't know about on this one, shifting incentives to prevention, meaningful use requirements in healthcare. If you don't know what that is, Google it. Around 2000, gosh, I can't remember the year now, 12, 10, 11, somewhere in there. They came out with meaningful use requirements, which were, there wasn't enough hospitals that were moving from paper records to electronic health records. So EHR, EMR, electronic medical records. So, which was kind of a big purpose behind HIPAA a little bit. So the reason why hospitals couldn't do it is a lot of them couldn't afford it. Those were really expensive systems. So they said, we will pay for some or all of your implementation of an EHR system if you meet these requirements. They were called the meaningful use requirements. The last meaningful use requirement was to do an information security risk assessment and have a roadmap. And for thousands of hospitals, it was the first time they had actually done a legitimate information security risk assessment. Even though that law was passed in 1996. HIPAA was passed in 1996. It was finalized. The security rule was finalized in 2003. It wasn't until 2010, 11, 12, when you incented people to do it, that they did it. It worked, man. I'm a big fan of incenting people to do it, as opposed to the current system. So anyway, we've got define negligence clearly, educate the legal system, shift incentives to prevention. Number 4, empower practitioners in court. Mandate expert testimony from actual security professionals, not just lawyers. We brought up Mark Lanchman here before. Legitimate security professionals, people that can validate and back up where they're coming from, their experience. So that's a big deal. CISOs need a voice in defining what adequate security looks like. If you don't make the subjective more objective, this is where you're at. And fix number 5, real consequences for leaders. Ultimately, they're the ones, and that's where the buck stops. Any good leader knows that SHI, whatever, rolls uphill. I didn't say the word, Matt, because I didn't want to give you $5. CEOs and boards should face liability for skipping security basics. No more hiding behind "we settled." Make leadership accountable before breaches hit. So actionable challenge. So those are the 5 fixes. At least they're starts for communications. for discussion. I'm not saying, I have all the answers, but you got to start somewhere. The truth is you can't improve anything unless you started with something. So start with something. Just throw it out there. It might be the biggest piece of crap ever, but at least you got something to improve now.
That's a swear word.
Crap?
Maybe.
I disagree. No. I ain't giving it to you. Is it? Maybe?
I don't know. The S variant is.
All right. I'll give it to you. So now you owe me $5. All right. Here's your actionable challenge for listeners. Ask your legal counsel or leadership, if you get a chance to ever talk to them. What's our plan to prevent a breach, not just settle one?
If the answer with our attorneys say, you already know there's a problem.
Yep. It's a good tell. All right. Key quote here. Stop treating lawsuits as an incident response plan. Prevention should be cheaper than paying lawyers. If you're doing it right, that's going to be the case. All right, that's it, man. Let's close this sucker out. The closing rant for this whole episode is, breaches shouldn't be jackpots for lawyers. It's not just. And again, I'm not blaming the lawyers. I'm blaming the system. For the lawyers who don't, obviously in every population of professionals, there are people with no integrity or that are just complete jerks. I'm sure the legal profession is no different, but to generalize and say the lawyers are the problem, it's the system that's the problem. Prevention shouldn't take a back seat to payouts, but until we define negligence, educate the courts, and hold leaders accountable, nothing changes. Class actions don't fix broken systems. They never will. They just pay the bill. We've had enough. Prevention needs to pay more than lawsuits. Next episode is episode 46. That's part 5. And Riker kind of already hit on this a little bit. Selling fear. This is about us, our industry. Selling fear, why the industry loves the chaos. They say they don't, but why do you keep causing so much of it, man? You must love it. It's like an addict. It's like an addict. Say, I don't love chaos. It's like, you're causing a hell of a lot of it, though. Maybe you do like it, or maybe you didn't know. But the truth is, confusion sells. Confusion sells. It's so easy to sell people things when they don't understand what you're talking about. They'll buy up whatever as long as it sounds cool. And Johnny next door has the same thing, man. I got to keep up with Johnny.
Leaves me to have to sort it out.
And me too.
Back end and make sure you get the most value out of it.
So confusion sells. Simplicity doesn't. That's intentional. It is intentional. It may not be fully conscious, but it's intentional. We'll rip into how vendors, consultants, and even so-called thought leaders. There's a lot of thought leaders, experts in this industry. And it's like, what the hell did you just say? Did you just gave that advice? Let's talk that through logically. And no, that doesn't make sense. So even so-called thought leaders profit, especially now. Everybody's an AI expert. Oh, you want to be an AI expert? Here, attend this, these 10 videos on Facebook and you'll be an AI expert too. Lord. All right. They profit from keeping cybersecurity complicated. And this is why clarity is their worst enemy. It's our greatest asset. So
more questions.
Yeah. Simplify, man. Oh, geez, simplify. Unless you like high blood pressure and, panic attacks, sleepless nights, 3:00 a.m. phone calls.
All right. You know what time it is. Don't forget to like, subscribe. You can find us everywhere. YouTube, Spotify, Apple Podcasts. Don't forget to share the episode on your socials, X, LinkedIn, what have you. Hashtag InfoSec to insanity. If you're even ballsy, go tag a lawyer. If you have a story to tell us, don't forget to email us, show@infosec2insanity.com.
Awesome, man. Good work. And I haven't even started advertising any of this. I don't post much about these upcoming shows because I feel like we kind of need to get our blank together a little bit first. But it seems like every episode we're getting our blank together more and more. Peace out. There you go, man.
There you go.